licensing, yeah.
I'd like to reopen the
Planning Board special meeting. And the Tiverton Town Council portion of the special meeting is also reopened. Back in session. And number 2 is a general discussion regarding quarry licensing. In fact, it's about the process of quarry licensing, the process and procedure. Yeah, I just wanted to address this very briefly. During the recess, I was advised by a couple of people that they're here to address the issue of the quarry. My first reaction was, based on what little I was hearing, was that the comments were really being directed not to the process, which is the stated subject tonight under item 2, but is more directed to the licensing itself. My concern, and I don't pretend to have any expertise in this area, but my concern was that, have we given an appropriate notice for a public hearing? I think we have, in a broad sense, but we haven't, but without any specifics. The concern I expressed to Mr. Tights, and perhaps he can give us his suggestion, his recommendation, is that I'm not sure that not having given notice to licensees, that this issue of the license itself, that is complaints, would be addressed tonight. It might pose an issue. And if that's true, perhaps this shouldn't be open to public discussion tonight. Now, I'm sure Mr. Tights can give a far better explanation of what I was trying to conceptualize at that point.
At least far longer, I can,
Yeah, okay.
as a lawyer, I can talk, well, you're a lawyer too, so I can talk longer, but I'll try to be brief. I asked that, I was one of the people asking that this be put on the agenda, because this has been a concern that's been out there, and I think we'll get into this when we talk about the process, but something that's concerned me for a while, and we've had our quarries in town in various stages. We've had one that was in, more than one that were in receivership for several years, and we were kind of prevented from doing anything while they were in court, and there was a stay from the receiver. We did have one quarry that's gone and, gotten its license renewed properly. We have another quarry that claims it's not a quarry, but just doing clearing of land, and we're currently in litigation in both Rhode Island Superior Court and U.S. District Court with that one. So we have a kind of confused situation. We do need to, I think, address it and move forward and deal with it once and for all. And that will happen with basically pushing forward on the licensing of them, and there will be public hearings with all of them. It was not at all the intent tonight to have any public input on the quarries. If that were the intent, then this would be a special meeting and it'd be listed. But it's part of the workshop, and it was just meant to be a discussion.
It is a special meeting.
It is a special meeting, I'm sorry. Well, that was actually because we thought we might be dealing with other stuff, too, with the administrator.
But it has been advertised as a
Okay, special meeting. But it's not, but I'm just telling you, my intent was it was not intended to be for public comment. And I certainly wouldn't want to hear any public comment about any particular operations, because those people aren't here, they're not aware of it, they haven't been given any notice. My intent was hopefully just to talk about it with the council, which is the licensing body, and the planning board, which is really key as far as a recommendation. The zoning official is also involved, but as far as a board, it's the planning board, and talk about the process and try to get an idea of the time, because one of the things was I had told the council initially we were going to get this, and we're going to get this all done before November 30th. But then I realized that we really needed to fit this into the planning board's time frame as well, and they have other projects and large projects, including the rezoning that we're here tonight on, that are taking up their time. And so I wanted to try to get the input and make sure that we're working together moving forward with this. So that is why I would strongly recommend not to be having public comment on this at all tonight.
Okay. If I can just add, then, I apologize to everyone. When I arrived tonight, I was told that Ed and Denise would be late. Would you take over the chair? If I I read the agenda notice in one way, the way I think Andy intended it. If I had known that there would be any type of public input that would go beyond the issue of the process itself, that's what I apologize for. I would have indicated to anybody that's here tonight to speak on issues of the licensing. But it's my understanding, and Andy, you correct me if I'm wrong, that this is really a matter of discretion for the town council, and each one of them have a right to indicate their viewpoint at this.
Well, actually, no.
Well, yeah, I'm a little concerned about that, too.
First off, Christina Medeiros is the vice president of the
Yes,
council,
okay.
so it's her decision.
I've offered to give her the job back.
She came in late with the other one, and the choice was either electing a new acting president for that item, or you as being the senior service person here, being the acting chairman now. But with her present, she's chairing the town council part of it. So from the town council part, it's really her decision. And it's up to her to decide if she wants to make the decision, she wants to poll the members and go by the majority of her members do it, that's her decision to make on that procedure.
Explain something to me, Andy. We occasion to allow public input on any number of, sometimes we have no ability to stop the public comment on some issues. Why is this a different situation?
Well, the public hearing, you have to listen to whatever comes before you. When you have a particular public hearing, as you will have with these when they come up for their license, it's a public hearing, and everyone has to have the right to speak. The rest of your items, the open meetings law is clear. It is, the public has the right to be here and see and hear what you do, but they don't have a right to speak on anything other than those specific items set forth in statute that require public hearing. Now, clearly, we live in a democracy, and our form of government here, we wouldn't be having all this stuff with public meetings if part of it wasn't including giving the public an opportunity to speak. And we have different mechanisms in our regular meetings, including the open forum, and allowing people pretty much to submit agenda items at will. We have those opportunities for people to speak. But it is at the discretion of the body, and particularly the person who's chairing the body, as to whether to allow people to speak, unless it's required by law.
I will just say that I have no problem with listening to what people have to say. I think it would be, as Andy said, specifics may not be, specifically naming people or quarry operations is not probably helpful, but I think it would be helpful to contextualize what we're talking about. I mean, we don't have a heck of a lot of background information on this, and we know that we've had complaints about quarrying operations, and we've had, or rather, the effects of quarrying operations, and we've had some interest in finding out the licensing process and procedure. And I think if people have something constructive to add, that would only help our understanding of the issue and help us talk about it a little bit better with some specificity.
That is my opinion also. I think that the public will have the right to speak, as far as I'm concerned, as long as you're speaking to the agenda item and we're not talking about specific quarries in town. But I'd like to hear, Jim, what is your opinion? Do you think we should have a public?
I'm not against hearing what people have to say. Obviously, we can't discuss, like I said, particular items, whether they should be license removed or whatever. We can't discuss that, unfortunately. But I would imagine that what some people have to say might have to relate with how licenses are granted or things that we should consider when granting a quarry license. So I'm sure they have input on some of those items.
Joan?
Additionally, I agree. They might have questions that they need more information on, and things that we might not think to ask, they may think to ask, and they may want that information and need that information to proceed in their specific cases. So I think it's worthwhile to have the public speak.
I don't have any issue with having the public speak as long as it's part and parcel to the process. I think it's not meant to invalidate anyone's comments or passion around these certain situations, because I'm sure there are very valid things that need to come out. I think it might be a very slippery slope and very easily, dive into entity-specific operational type of comments, and if we're going to allow this, then I think folks need to be folks in the public need to be okay if we cut you off
I was just
at
going to
the
say
moment.
that.
Yeah.
Yeah,
I'm just-
I'm comfortable and confident with Denise's ability to rein in anything that goes far afield of what we're supposed, what we're talking about. I think we're all adults and we can play it by ear.
Jay, anything else to add?
No, I think I would pretty much go along with Mr. Gerlach's thinking on this, but keep in mind that when the licensing process comes up, when an actual licensee is before us, you would have to return and at that point address any specific complaints that you might have about a licensee. That is not the scope of the agenda item tonight, which is specifically limited, quote unquote, to process and procedure of licensing. Okay.
So after Mr. Lambert just said that this is only comments on the process, it may help us to make a decision on the process, but not about specific companies. Because when they come in, then you have the right to speak, and they have the right to defend themselves. Okay? All right, so we'll continue.
Can I, may I? I just want to, I think maybe the best way might be to start with a little bit of just an overview of the situation, at least as I see it. And you've actually got handed out, the planning board members had this, and I want to thank Kate for, there's a little kind of collection of the rules and regulations that apply in the town. And I'm going to say what I sometimes say when I talk about HUD closing statements. Like a good government document, you go to the back and work your way forward. And I think that's, the first thing to realize is that our zoning ordinance considers quarrying or mining for sand, gravel, rock, or minerals to be a prohibited use. It's not allowed as of right or by special use permit in the town for any new operation. Somebody comes in, if they don't have a pre-existing right for it, it's not allowed. So that's the first thing. Nobody new can come in to a site that hasn't been used before and use it. Now, the people who do have various rights, who have been operating it, there's kind of two levels of pre-existing rights. The main regulation of this came in 1974. And now I'm moving back to the front. It talks about earth removal, and the top of the second page talks about if you had the license, if you had the intent to do it, if you, basically, January 28, 1974 was the key date. You had to have meet the 5-part test there in order to have the right to keep doing it going forward. There was various litigation. This is previous to my time as solicitor, but I was involved tangentially, and I'm involved in other communities. There was litigation. The problem is the general theory of non-conforming uses. If you're a use that's legally non-conforming because you existed before the zoning ordinance said no, you have the right to continue your use, but you can't expand it. If you have a little mom-and-pop convenience store, you can't turn it, you can't expand it into the rest of the building, turn it into a store 24, you can't expand the hours. You're limited to what you had. You have the right to maintain what you had, but you can't expand it. Quarrying and sand and gravel operations, by their very nature, expand physically. They move outward. They can't exist any other way. It's inherent in their use. So the courts have looked at them in a different light and said, well, if you have these operations, you have the right to continue to keep quarrying. That includes expansion, that doesn't mean it's expansion of a non-conforming use, it's a continuation of your use. And what the town of Tiverton did is, and I, as I said, I was involved with this with other communities, we've done it, picked up the language from certain court cases and basically give people a safe harbor and say, okay, whatever you're doing up to a certain point, and if you go up to 25% beyond that, you have, that's allowed. That's part of what's the safe harbor that you have as part of your pre-existing non-conforming use. If you want to go beyond that percentage, then you've got to get a special use permit to be able to go beyond it. You've got to come in and show us that you're, doing certain things as far as meeting the provisions and set forth the standards, which I'm going to come to in a moment, which basically deal with reclamation, that you're going to make sure you're not damaging the groundwater, you're not damaging the neighboring property, and that you've made provisions to reclaim the quarry when you're completed. And then the final element is that the town has a process of annually licensing quarries. And as I've indicated, the town really hasn't, it's not through the town's fault, but we have been really not keeping up with all of them. And I guess at this point, I want to just state that I am going to mention one name, and that's Site Ready LAL Construction, okay? If anybody has anything about that, that is not a quarry. The town's position on that is that they do not have the pre-existing legal non-conforming use to operate as a quarry. Their position is perhaps that they had the right, they've made some statements and so forth through the years, but since 2001, claiming that they were a quarry, and they're also claiming that they have the right, they're not really quarrying, they're just blasting rock out of the way because they're trying to clear more flat area for their permitted use within the industrial zone. So we are currently in litigation with them in Superior Court over their various activities of legality, including that issue. We have asked for a declaratory judgment of the Superior Court that they do not have any rights to operate as a quarry there, and that what they are doing is quarrying and therefore illegal. They have sued the town in federal court, asking basically the opposite, that they do have the rights and asking for damages. So that issue is kind of off the table. The town is still pursuing it, we're still vigorously, actually, I give you Monday night, there's several more filings of the federal court case between our lawyer over the interlocal, motions to dismiss and replies, and motions to strike exhibits and so forth. That's vigorously being contested. Unfortunately for the town, it's mostly being done at the expense of the interlocal trust's attorney with your insurance. So, of the others, there's apparently 5 that are non-conforming, pre-existing non-conforming uses. One of them, a couple of them are inactive. One of them does have a valid license, and then a couple of them were in receivership and are now out of receivership and functioning, and that's what's triggered the response that we want to get back on the cycle here, and we want to require them to come into the licensing. And the current requirements of the licensing are set forth also in the material you have there. And the key being is that they're supposed to provide us with a plan. They're supposed to provide us with the plan, the contours, showing what's going on now, and showing what their plan for future excavation is, and also showing how that they're going to reclaim it when they're done. And that's reviewed by our engineers, which in this case is Commonwealth Engineering as our consulting engineers, reviewed at their cost, and a bond is set. And the problem is that the bonds in the past have been ridiculously small, such as $500 or $800 to, reclaim acres and acres of land, when in fact it's up to potentially millions to do it properly on the largest site. And that's where I expect that we will have conflict, but that's what I want to basically move forward and basically get the quarries that are out of receivership, get them to come forward, and the ones that are not operating, if they want to keep operating, if they want to, even if they are not operating, if they want to keep their legal right, they got to come in and renew that license. And that means they've got to provide the plans, and they've got to have those plans reviewed, and then they've got to provide the bond. And that has to be done before they have the hearing for the license. And I guess, and I will say, the one that does have the license, we did have it reviewed, we had the bond figure came in quite high. The owner of the quarry complained, said that's not realistic. I shouldn't have to truck, your figures include me trucking in a lot of dirt to cover, but in fact, by scraping and filling, I've got a lot on the soil, on the site, I don't need to bring it in. We said, okay, have your engineer talk to our engineer. And our engineer came back and said, yeah, okay, it can be reduced to a certain amount, and that's basically what we're doing. We have our town engineers, we rely on their independent judgment. And I think a lot of that would be the same thing here. So that's what I'm looking to do, is to basically send the notice, putting everybody on notice, the quarries, that they must come in with these things. And the planning board's important, because the planning board is really the first step, going through them with a recommendation. We're really depending on the planning board's expertise. They deal with site development and subdivisions and land development all the time, and looking for them kind of to be the first breakwater, if you will, to deal with this issue, as there no doubt going to be complaints about, how much the bond is and when does not have to be reclaimed, before it gets to the council as well. So that's what leads me to tonight.
Yeah, quick question, Andy. You said there were 2 inactive, or one inactive?
I believe there are 2
Two.
inactive.
How long do you, so they're unlicensed and inactive.
That's correct.
How long do you have to be unlicensed and inactive before you have abandoned the use?
Well, that's the problem. Under Rhode Island zoning law, there's not a time limit. As long as there's nothing, as long as there's no action or lack of action that would lead you to believe that they had abandoned the use, they maintain that use. So that's why I want to make it clear that the town is in fact requiring that license. If you want to maintain the non-conforming use, you have to come in and renew the license. We have not done that, as I said, because they were in receivership, so we couldn't really apply the pressure.
So there
Now,
were-
I think we can.
Those were the ones that were in receiver?
Well, one of them was in receivership. One of the ones in receivership was active, one is inactive. Another one that's inactive has other problems with drainage and flooding. They couldn't apply for a license because of the various flooding issues that hopefully are resolvable now, and, that's what we want to push that issue now, to say, okay, this is it, and yes, if you do not have, we don't want to make it unreasonable and say, yep, come in within 10 days, and, or else you're forfeit. But we want to give people a reasonable time and say, but you do have to come before us, and you do have to meet the requirements of this, or else you're going to lose that non-conforming pre-existing right. The
So
grandfather
if we
right, as
de-
people
If
call
we
it.
deny or do not approve their license,
Mm-hmm.
they lose the right to
Come back in.
come back and apply?
Right, yes.
Okay. How is that different from them not, of their own action, not pursuing a license? Because it's
Well-
a definitive action?
Yes, yeah. I mean, as I said, I would be hesitant because of the town's, lack of strict enforcement
Yeah.
before now. I would be hesitant to go into court trying to say that just because they hadn't renewed it before, because we had them spread out over the years, they weren't all at one time, we didn't send a notice to them saying you must renew. Yes, they should have known, they should have come in and renewed on their own, but we didn't send them the notice either. So because of that, I'm hesitant to rely on past action to do it, but certainly I think we can do it at this point moving forward.
Okay. So when we approved licenses in the past for quarrying operations, subject to meeting all legal requirements, they were granted not meeting all legal requirements, or?
Yes and no?
Focus on the yes first.
So they didn't meet all legal requirements.
They weren't, I'm sorry to butt in, but
No,
they-
butt in.
they weren't issued by the council previously.
Right, they were issued by the building official.
So it's
Ah.
a
So-
different process.
I see.
And then when we did the codification, we changed it, moved it to the council, and changed the timing on it.
And when was that?
About a year and a half ago, effectively.
2010.
2010, okay, so it's two and a half years ago.
And after 2010, the council made that decision.
Yes. Well, you didn't actually have them in front of you, except one who actually, you only approved
wasn't
one.
there, I'm just
The
curious.
council only approved one who actually did comply with all of it.
Okay.
The council didn't approve any that didn't comply, but there wasn't anything before you
There's
to.
no one applying.
Right, because they
Okay.
didn't meet the standards to even apply.
Okay.
So at this point, we only have one quarry that has a
A license.
Yes, you have only one quarry that has a current active license meeting all legal requirements.
And it meets the bond, it meets
Yes,
the plan, it meets the...
Right, they provide the plan, as I said, that's the one, they initially complained about the bond as part of the process.
right.
But came to an agreement, and they did post the bond as finally determined by Commonwealth Engineers. Yep.
So may I ask which one it is?
Yes, that is CMC Family Limited Partnership, Charles Coelho, 1764 Crandall Road.
So that's,
And he may actually not be doing much.
right, I was just
But
curious.
for the license part,
He does have,
he does
I don't
have a valid license. He's done it, and he's posted a bond for a couple of $100,000, I'm not sure.
so the others don't have a present license.
That's correct. They don't have a current active license.
Yeah, satellite view of his property shows absolutely no quarrying going on
I was
whatsoever.
wondering, I didn't...
So,
But there is quarrying going on in town,
yes, there is.
so
Okay.
they will have to come in and,
They will have to come in, yes.
okay.
Sooner rather than later, one would presume, yes?
Yes. Well, that's what I'm trying to,
So what action do you need from us tonight?
I,
What do you,
I don't need any action per se. I guess I just wanted to raise it. I wanted to hear your concerns. I should like to hear the planning board. Also like to hear the planning board's idea of what kind of time frame you think you're going to do it, because when I send out the letter saying you must have your, they've got to actually get the recommendation from the planning board before their application's even complete to come to the council. I want to know what's a reasonable time to tell them on the letter, that the certified letter I'm going to send them, that they've got to have their application into the council. I want to know what what you think's a reasonable time frame to do that.
Well, I would say it would depend upon them supplying us with all the proper information. Now, according to Appendix A of the zoning, all of the quarries in 2001 were supposed to submit a survey of the quarry as it existed in 2001. So that'd be one of the items that we'd be looking for, because it's in the code. I don't know that
if they did?
more than one even submitted one back then, because that was where the 25% expansion started. It was in 2001. So that would be first, and then if they have expanded beyond the 25%, you said they need a special use permit, so we'd have to determine if they have expanded beyond the 25%, do they have a special use permit, you know, of the ones who do apply. And then, well, the other thing would be probably their ability to meet the surety. The information I have is that the sureties were put forth from Commonwealth. Commonwealth was asked back in 2008 to come up with a surety figure for the reclamation of the quarries that existed at the time. And there was a big complaint by even one of our own departments about the cost of the surety, because it was a large amount, but that's what it's going to take, as Mr. Tite said earlier. That's the kind of money you're talking about, to reclaim these properties, to put them back into some kind of a use when they're done quarrying. But there was no enforcement, as I understand,
I've been told, there was no enforcement in 2008 for the quarries to come forth with the surety at that time. I'm going by notes I've been handed and things I've been told. I wasn't part of the process back then, but, so, I mean, I think the planning board, if I may speak for the board, is that I think that would be where we would start and look for those initial documents. You know, I don't know if you're going to have Commonwealth redo sureties again, but if so, have Commonwealth redo sureties on the different quarries that are going to apply.
Is that surety a standard flat fee regardless of operation size, or is that kind of based on?
I think it depended on the size of the quarry.
Right, it's very specific. It's the cost to basically regrade it, so you're not left with granite cliffs and moonscape landscape, that you're going to be covering things with dirt so it'll grow, and there's also language about the natural slopes and so forth, so it's very specific for each quarry.
Okay.
They have to look at each plan.
And that's under what jurisdiction?
It's under our jurisdiction, under the state authority is probably the earth removal, the Enabling Act for Earth Removal and Soil and Sedimentation Erosion Control that's given to the town to control that, as well as the zoning power.
And I guess the other question I might have is, you said if they expand beyond the 25%, they need a special use permit.
Yes.
But what is the maximum that they could expand beyond that 25% from 2001?
I think you actually have to go back to 1974, where it talked about like surrounding 20 acres. Although it talked about 20 acres of industrial zone land. It doesn't specify, there's no specifying what the maximum is under the section that talks about the 25%. So one could say 20 acres if it's industrially zoned. Beyond that, I think it would have to be, that would be something that the zoning board would be looking at on the special use permit. If you've got 100 acres of industrially zoned land, I think it's more appropriate to allow, a larger expansion than if you've got 20 acres of residentially zoned land next to other neighborhoods. I think that's the purpose of the special use permit, to look and see what the environment is.
So, and then following along with that, I mean, depending on where they stand right now, they would probably need to submit another survey plan, a current survey plan.
Right.
And then the surety would be looked at after that,
Right.
because you'd have to know how much they've quarried and how much reclamation needs to be done. So,
Is this 25% expansion quantified in a physical area, or is it a cubic kind of factor?
Most of the courts have treated it simply as a horizontal expansion percentage rather than cubics, not really taking the deeper aspect of it, but as far as how it's spread.
Peter?
We have the satellite photos over the years, and we know what the expansion is.
Yeah, that's why I was,
This particular thing was one of my pet peeves, that I thought that when we got a town planner, that the planning board might actually be able to direct him to do the issues of zoning and tackle the quarries and so forth. And we didn't seem to get much cooperation. When I read this over, I made 22...
Can you talk into the microphone, please?
When I read this Town Code, Chapter 38 over, I made 22 recommendations to myself that I thought needed to be changed. And I'm going to limit it at the moment, rather than boring you with this whole thing, to fencing and dust control. If we go to dust control, and we see that calcium chloride or oil should be applied to the non-paved areas to keep dust down. Now, the oil should be out, And water is not mentioned that everybody uses to keep dust down. Water is not mentioned that it should be used. When you go to fencing, fencing is only asked for up against residential areas. These quarries should be fenced all the way around. It's a hazard. It's also if the town doesn't require this fencing around it, somebody wanders into the area and falls down where it's blasted, the town could be open for litigation. But, so I made 22 things here, and when you say that we should have a surveyor come in, there's no classification of what survey we should have. Is it Class 1, Class 2, Class 4? So there's so many open-ended things in here, in my opinion, that they need to be addressed. Not that the licensing and the bonding doesn't need to be addressed, but when you're asking for a survey, you really should know what survey you need. There's also no definition here at all that I can see of what a gravel pit actually is, nor in any place does it say that if we're grading our land to build a building on a private property or a gravel pit, that they're allowed to grade it to grade of the road, or we can blast down 10 feet to put a foundation in, or 20 feet, or 300 feet down. It's so open-ended, it really needs, in my opinion, to just be rewritten. And those are 3 points out of 22 I have here.
Mr. Tice, didn't you say that this referenced state law?
Don't you agree?
No, I think the authority from this comes from
Okay.
state law. There is an enabling act for soil erosion and sedimentation control, which I think is where the authority that the town gets to do these
Okay.
things.
Thank you.
So, what about the issue of the methodology for which, for lack of a better term, and this is my own term, the methodology for which earth is removed, or gravel is created, or aggregate is aggregated, for a cute term. Do we regulate, or do we have any licensing authority, or where does the authority come from to, operate a mechanical device versus a chemical device?
Blasting is regulated by the state and the state fire marshal's office, and they have preempted local authority on blasting. So if the use is otherwise permitted, then the ability to use blasting to achieve the use would be allowed.
Okay, I understand that. Is there, are there any, what are the requirements? I mean, it seems like if they're doing the earth removal through blasting, I feel like that sort of doesn't circumnavigate, but it sort of takes us out of an equation that would otherwise make us on notice, or notice, I think, would be something, right? Don't you have to notify the town that you're going to be blowing things up?
They have to, yeah. They do have to notify the, they notify the fire department, yeah, that they're going to be blasting.
Okay. Do they notify neighbors or abutters?
No. No, they do it at their, one of the things, to the extent that damage to neighboring property is done, they do it at their own risk. If they don't, I mean, I'm more used to this in the context of people doing it to actually develop, to blast out a foundation for a building and so forth. And the usual procedure there is to ask the neighbors if they can come in and basically do a survey of their property, photo survey of what's the condition of your property, what are the cracks in your walls and so forth now before we blast, so that if we blast and you claim there's damage, we've established a baseline, because they are absolutely, or what we call strictly liable for any damage they do to neighboring property. There's no question, it doesn't matter whether they were negligent or not. If they blast and they cause a crack in the wall of neighboring property, they're responsible for it. That's a damage that they are responsible for. So it's to their own advantage to do it, and if they don't, they run the risk of being subject to suit for the damage.
So I imagine, at least at the fire department, there's a record kept of all all recorded blasting activity. And I mean, the clerk, I don't know what
They
that,
have been coming through the dispatch of the police department and reports to the fire department. But all it is a phone call that says we'll be blasting within 5 minutes. It's not a warning to anybody, it's just, they just let it be on record that they are blasting.
I know, but if we keep a record of, you know,
Yes, the fire department.
dates and times, then if someone comes in a week later and says, my house fell off a cliff, was there any blasting going on? We would be able to at least pinpoint if
I'm
it,
sure the
of
fire
those who
department
call.
has specific.
right, oh, yeah, of those who called,
Right.
okay.
So before, to Mr. Corr's point, and I'm certainly only privy to the 2 or 3 that you just brought up here, but, I mean, should we take a look at these articles for updating or taking a fresh pass to see if we could improve upon them? But before heading into the licensing
Right.
arm of things?
These are types that could be changed without going through
No, these would,
formal.
Still have to have a public.
these would have to be noticed, these would have to be noticed at least 21 days in advance with a public hearing, because they'd be ordinance amendments. And anything in the zoning ordinance also requires not just once, but 3 weeks, 3 successive week notice. So it would take a little bit of time to do it.
As a time, it would take a minimum of 2 months.
Probably, yes.
Okay.
Which, I think it's a good idea, actually. It would probably make the job easier on
Wait,
the
when-
next step.
People are leaving, and I will open this up to public discussion right now, but please limit it to only the process.
I have a question for the solicitor.
Mr. Rigo, just introduce yourself. Mr. Rigo, just state your name and address, please, for the record.
Would a cease and desist order be appropriate now, since this quarry that we have in our neighborhood has been operating without a license?
No. That's what I'm saying. We have to give them the opportunity. We have to make it clear that there is a deadline and the renewal notice, and give them the opportunity to apply for the license or not apply for the license before giving a cease and desist.
Well, he's got been using the stone crusher even last year.
As I said, I'm talking about the general process. I'm not
Yeah, the
talking about
general
individual
process.
operations. You need to come up,
Please
please,
come
and give
to-
your name
yeah.
for the record, your name and address for the record, please. Even though it's not a hearing, we always, clerk needs it for the minutes.
My name is Marcia, and I live on Paul James Drive. So are you saying that if I wanted to buy a car and drive it, I wouldn't need a license right away, because you could just, the cops wouldn't tow that car away because I didn't bother to apply for a license? Because then they would have to notify me that I needed a license to drive that car. Or if I opened a business in town, you couldn't come shut it down because I didn't apply for a license for that business. That's what you're saying.
No.
No.
Well, these quarries are operating they're operating in this town with no license. Where do you operate a business with no license?
They did have licenses.
Yes.
And I think that's the thing. If you opened up a business in town and you had a license, and then you didn't renew it, and we didn't tell you to renew it, whether it was, a victualling license or an antique dealer's license or something, we would not, in fact, come in and say, shut you down right now. We would provide you and say, oh, you need to come in and get your license renewed. And then, if you don't come in for it, then we would shut you down.
So
But
if you own the business and I buy it from you, don't I have to get a new license?
you do. I'm just telling you how,
Well,
the position that we have
We
are on it.
understand that the process is wrong, and we understand that.
So if I didn't apply for a license when I bought somebody else's business, I'm not grandfathered into your laws, your previous not renewing a license. I have to apply for a brand-new license, not a license renewal. So because I didn't.
No, not on
No,
this state,
no.
because the license goes with the land in this case, not with the owner.
But there was
The
no
use goes-
license with the land when
There
it was
there were
purchased.
There were licenses originally. That's the point. Whether they were properly issued or not is besides the point. There were licenses issued under the old system. There were licenses issued. So we have to provide people with this opportunity in the due process to do it.
So if I bought your car that you licensed
That's
and
not the
drove it
same,
around for a
it's
year
not the
until I got
same,
caught?
it's not the same thing.
I just want everyone to understand that we know that there's a problem. That's why this process is happening now.
The process should be that they should have a license to operate a business.
But
If they
he-
don't have-
but Mr. Tights
I
tried-
think anybody knows that.
I think Mr. Tights tried to explain that they did have a license. And they did not, we did not go through the proper steps to have them come in and renew the license. So now, that's what we're trying to fix. Am I right, Andy?
Yes, yeah, I mean,
And
I mean, the
I
best we
understand it.
can
I
do
know
is
it's
going
hard
forward. We
For me
can't
to tell
back-
you to have patience,
Yeah.
because I understand this disrupts your life, but we are trying to fix it. We are trying to do this and move this forward.
Okay, I have one more question.
Okay, come sit by the mic.
Just come close enough so you can.
Yeah.
You mentioned when you were first speaking about surrounding property, damages to surrounding property, okay? Who enforces that they take that precaution?
that is a private issue between the property owners, between the
But if you-
use.
But if you put it into the licensing process, then.
No, it's not into the licensing process. I'm
The
talking about
blasting
that's-
is a state.
The blasting is a state thing, and the damage done to blasting is just a matter of state law. That's considered a tort, but it's not something that the town enforces. And we can't actually, because the state's the one that does the blasting. If you have complaints, it should be directed to the state fire marshal's office. They should be the one there controlling and saying, hey, we're getting complaints, you're using too much. You should be doing smaller chunks, you should be, whatever the problems are, it's really the state that's got the responsibility for it. And we are what's called preempted from regulating it. The state says that's our job, we regulate it, and stay out of it, town.
Okay, so whose regulation is the noise then?
The town has a noise regulation. And if there are complaints on that, that should be called, the police department has a noise meter, so that they can go out and try to verify if it's above the noise limits. There are different limits for different times, day and night, and for different zoning districts. And it's measured at the border of the property that's generating the noise. And if they're in violation of it, they can be cited and will be cited. But we need the complaints to get them out there to take the reading. We have to have some evidence of the violation above a specific decibel reading is the way it is.
And you're saying that's the police that we call for that?
Yes.
Yes.
Because they're the ones who are around
Because they
24
don't-
hours a day. If
They don't even know about the blasts when we call them.
Okay.
But call them the next time.
Call them and tell them you have
The
that
chief
it's
will
a
call.
noise complaint. Ask them to come out with a noise meter.
This is up.
My name is Bob Tolan from Linda Road, and I won't name any particular place. We have a pond in this town that supplies it with water. And these people receive the applications for licenses for quarries, correct? Does anyone ever check any of these quarries for depth, how deep they've gone? Are they below the high water mark of Stafford Pond? Are they above it? Are they flushing into Stafford Pond? Or are Stafford Pond flushing into them? Because personally, I fished at a pond that is no longer there. It's gone. And if you go on that map that this gentleman had, the two quarries, or not quarries, are less than a quarter of a mile from Stafford Pond, and nobody checks how deep they are. One of them has about a 60-foot cliff when it used to be a hill. The other one, who's not blasting, but he's blasting, it is to put his buildings in, is closer to Stafford Pond. Is he below the water line of Stafford Pond? Are we about to lose our drinking water or get it polluted from these places?
Andy?
Anyone have an answer? It's what irks me. I mean, I have a lot more complaints, but I can't mention names.
Andy,
Well,
do you have-
One of them.
The plan that they're supposed to submit is supposed to include elevations.
No,
So that-
excuse me, sir, not their plan. This town goes in with a surveyor and says, you're below depth, you're above depth, you're fine. Do we take the responsibility so that we don't lose our drinking water?
I don't think presently we do.
No, presently we don't. I mean, we have taken action, we did in fact, in connection with protecting drinking water, was that how we were successful in court in getting the Fall River recycling operation removed from the site.
Is there I mean, let's talk about this for a little bit.
Yeah.
Well, actually, DEM is on the
I was just gonna
groundwater
ask
issue. But given our success at that, it's probably something that we should be looking into as well. You know, we would have, Commonwealth's going to be reviewing the plans anyway, and I guess the answer is if we have any doubt at all that their documents and their plans aren't accurate with the depth, then we should be getting out there to try to look at it ourselves.
And that could all-
So basically, that has to be part of the process,
so that-
that the
That has to-
licensing process.
That has to be part of the licensing process, right. And I think it would be a good idea, I made a note, I think it'd be a good idea to send a copy of these license applications to both of the water districts, asking for their comment and input.
Is there any regulation, sort of to tie back to what Peter said earlier, is there any restriction or regulation, whether it be state or local, that limits the depth at which you can mine? I mean,
They-
certainly, there's going to be...
They can't go
common
into the
sense.
groundwater. If they're going into the groundwater at all, then that's a DEM's wetlands violation effectively.
But how does anyone know
Know
that
that.
these people have dug a 300-foot hole in the ground?
They don't.
Okay.
And the
If you
question-
need mining gear just to get into the, one of these things, it's not something you can see from the street. This is concerning, very much so.
The drainage section here is on the first page, and it only touches on surface and underground water, according to the code from, it's 1967, or it's code 1967. But it says that they're not allowed to transport the water, but it doesn't really explain how. It's another thing that I have a note on here that needs to be changed.
Yeah, it essentially just says you can't create artificial ponds and prevent water from flooding the surrounding properties, but it doesn't really...
It has no bite.
Right, yeah.
Well, I mean, there should be some sort of, if the licensing is annual, there should be some sort of inspection or something like that,
When this was written in the 60s and the 70s, it was not thought that anybody was going
Oh.
to go down 200 or
Yeah.
300 feet.
Yeah, no, I understand that this is old and outdated, but I'm saying if we're gonna take a fresh look at this and take this opportunity to make improvements that benefit the town and the townspeople, then that I agree with Brett, that that's very concerning, and we should try to figure out a way to monitor that more closely.
I don't think that rewriting this should stop us from trying to get these quarries licensed.
Yeah.
And bonded.
Right.
But, part of the bond right here, if you read this, it says that all they have to do on top of their rock is put 3 inches of topsoil. It's absurd.
Yeah.
So
Yeah.
it needs at least a foot of 3-inch minus on top of the rock that's blasted, and then maybe 3 or 4 inches of loam that's actually gonna, live.
Yeah.
So,
You can't put 3 inches of loam, as all this calls for, on rock, and expect it to grow.
Have to wash away.
I mean, there's so many
Yeah.
bad things in here.
so should we, as far as kind of pursuing, and the licensing is, different and distinct but related, but as far as, updating the ordinance to improve upon it, I mean, should we look to the planning board to provide some guidance here on recommended?
You ready?
Well, I was going to ask Bill, as far as the application goes, is it a one-page application, or is it something, a subdivision checklist? And part of the checklist, do they need to have an environmental review statement done?
At the moment, it's a one-page thing, and that's the problem. That's why I want to do it. As we've discussed this, and I think it would make sense to do a two-pronged thing. One is, I think, to start things, I think, irrespective of the licensing thing, we can demand that everybody provide us with their plans, certainly their 2001 plans, and put them on notice that they have to be preparing the other plans. And then I think at the same time, move to change the ordinance, and so that we could, in fact, have a more detailed application, which I'd like to, it should be a more detailed process. And part of it might be to actually take some of the stuff out of the ordinance and just put in the ordinance, shall complete an application, as prescribed by the planning board, or something like that, so that we could then put in regulations all the details that they have to have, and not have that tied into the ordinance, and which means it's so hard to change and cumbersome each time as things go forward. So I think it would be good, though, to get our stuff more in order before we have them in here for a public hearing.
But I think that this licensing procedure starting today needs to, because we've been so behind the 8 ball on this, every single one of these licensees need to prove to this body, that body, and whatever other body we deem necessary that they are not only in compliance with what we assume they will be doing under our newly crafted ordinance or regulations, but also that they aren't damaging the drinking water supply, or they're not damaging any infrastructure, or they're not doing anything that would otherwise compromise the structural integrity and sanity of the town. I think they've been operating kind of in the Wild West a little bit for the last 20 years, and I think that's the least we can do is make sure that we're satisfied that they're not endangering the health and well-being and the safety of the town of Tiverton.
Absolutely.
So, I don't know, I don't have rock climbing gear, but I'd be happy to.
Question there at the end, and I'm on the second page in section 3865, operations already in existence. That was the only place that I could find that it's that the whatever is submitted to the building official. So right now, are we trying to, are we thinking about having the application come to the planning board for its approval, and then send it along to the building or zoning official for enactment?
No, that is already there. If you look at, it's in the second part, Division 2 license, and if you look at 3883, as it's continued over to the third page there. The last paragraph, which doesn't really have a number, the plan required by subsection 1 shall be forwarded to the zoning enforcement officer and to the planning board for an advisory opinion. The
By who to the planning board? Or is it going to,
The zoning
By
first.
the clerk, no, the application's now made to the clerk.
Oh, and then she sends it to the zoning board.
She
and the
sends it
planning
to
board.
the zoning enforcement officer and the planning board for an advisory opinion. And then and then what we've said is, the advisory opinion shall accompany an application to the town council for a license. So until you give an advisory opinion, it doesn't even come back to the council. So they can't circumvent the planning board.
We don't want to delay trying to get
No,
these
right,
licenses.
I think it's a two-pronged thing. One of, to make sure they're at least complying with what we have now, as weak as it may be, 3 inches of dirt that it may be,
Right.
and that they're not causing, a public health, safety, and welfare harm, which would include the public hearing, at least get that, and at the same time, as a parallel track,
Rewrite.
get working on rewriting it to do it.
Yeah, I think the
So
most
that-
important aspect is making sure that we're not, these guys aren't engaged in an activity that would damage. I think.
Right, and it might make it easier, because we might well have several of them drop out
The
completely.
reclaiming aspect, I mean, we're not going to have any of these things close in the next year anyway, so theoretically, I mean, that's the risk we run, I imagine, is that I imagine they're not going to be,
Well, the one that may close is the one that's not operating, that has the bond.
so.
That's the one that's talking
you know,
about
I
switching
think
to another use anyway.
It's
so-
important, but I think the most important thing is getting, even if it's just 3 inches of topsoil, the likelihood that those guys are going to complete that plan in a year's time, which is the licensing period, we'll have another swipe at this, you know,
Well,
at that
and it's
time.
also important to have the public hearing so that, you can hear from the neighbors and that they can
Yeah.
hear, and that this gives you something to hold over them and say, if you want your license renewed, we've got to stop hearing these complaints. So that's part of it.
Any more?
When the planning board does their advisory opinion to the town council, just to review, what are the basis of the advisory opinion? Is it the standard purposes of zoning, the
No,
safety, welfare?
I think it's more just the health, safety, welfare, and specifically looking at the plans that are provided. Are the plans that are provided, both as the baseline and the proposal, accurate and correct, and relating also to Commonwealth and the bond amount? I think that's basically what we're looking for on it. Not so much the general purposes, but specifically reviewing the particular development.
And I think at least somebody, I mean, I don't know what the procedure is in the past for the planning board, but we've got to get somebody out to the site. I mean, that's paramount to understanding the scope and scale of these operations, is looking into the whole. And, we may not be able to glean much information, but if we can figure out that, hey, 5 years ago, this thing was half the size it is today, we got a problem.
And I think we have that right. I mean, that's part of licensing. So you want the license, you've got to allow examination.
Okay.
If you're not going to allow examination, then, that's part of that's a fundamental quid pro quo of a license that I think a court would uphold. That someone can't come in and apply for a license and yet deny you the right to inspect their property.
Is there any more public comment?
Hi, my name's Amos Lamora. I live on Linda Road. I just wanted to mention a couple things. One thing is, they set up a seismograph, whatever, to indicate how strong the blast was, whatever. What they failed to do is, they're blasting ledge. So depending on where they place that, they're not going to get a true idea of it. I know when they blast, my windows shake. I wouldn't say things are falling off the wall or anything like that, but I've complained constantly. You know, it's, you say that the companies will come in and they'll check, and they'll inspect your home and everything to see how it was prior to when they stopped blasting, okay? They've never done that to us. And when people have complained about damages, now you have to go after a company with deep pockets. And what happens? Nothing. So, the state issues the blasting permit, the town issues the permit for the quarry. So the town is responsible, as far as I'm concerned, not the state. So I have.
Thank you.
Andy, can't we add up into the process that an inspection, mandatory inspection, be done of the property owners that hoarded these quarries?
Enforcement, who's going to do it?
Well, that's state,
Well, they have to come
right?
up with money.
Well, I think we can, I do think we can require an inspection. And I guess my thought is probably that we would want Commonwealth, or perhaps we want even a more specialized engineer to inspect it.
Or independent, they could hire an independent engineer too, I guess, if they want, right?
Um,
We allow that now.
Right, well, I mean, well, that's what I'm saying.
They
We,
have to come up with the fees and pay.
from what I've heard tonight, I think we would want a separate independent inspection as well as part of the verification. Not just having Commonwealth review the plan of some other engineer, but to actually independently go out there and check it. Now, I'm not saying they're gonna completely redo a Class 1 survey of the entire site, but they should be going out there on the site personally to check and see if it's reasonable. If they do have any concerns, that further investigation is warranted. And I don't think that's I think that's something we probably either, as I said, have to have Commonwealth, or if they don't have someone, we may need to have a more specialized engineer.
I'm not talking about engineering plans, I'm talking about mandatory inspections of the property owners
Right.
that's around the quarry.
Oh, the property owners? I don't think,
Why can't we do it? The state's
Is there
gonna say
anything that
no,
for
that's
business?
Not reasonable?
I think because that's directly related to the blasting.
Mandatory, before blasting, we have a benchmark. Why don't we try it? See if we get shut down. If we do get shut down, I don't think we're gonna get shut down. It's one of the requirements to run a quarry, you gotta do a survey of the surrounding properties within 200 feet, say, or whatever. Get a benchmark, and then you go on and do your operation from there. If there's a problem with that owner has something to fall back on, and that company has something to fall back on. They did it or they didn't do it.
Well, let me think about that.
That being the ledge can go on for a long way.
Yeah, I mean, you have to figure, what distance are you gonna say? You're gonna say 200 feet? You're gonna say 1,000 feet?
You
or-
can't go to, you gotta say a reasonable, logical distance.
Well, if people feel something, come stay at my house when they blast. Don't let them know, because believe me, they'll water down the blast.
And how far away are you, sir? I think we're just trying to,
Down toward the bottom of Linda Road. So I'd say,
feet, quarter mile? I have no idea.
quarter mile.
Under a quarter mile.
Well, then,
So all I'm trying to get at is trying to answer, you know, how big of a radius might